A last will and testament is the best-known estate planning document in America, but in Florida, it has very specific rules. Get one wrong, and the entire document can be thrown out. A last will and testament, usually called a will, is a written legal document that tells the probate court how someone wants assets distributed after death. In Florida, wills are governed mainly by Chapter 732 of the Florida Statutes. A will does four main things. It names the personal representative, the person who administers the estate. It names the beneficiaries, the people or organizations who inherit. It can nominate a guardian for minor children, and it directs how specific assets should be distributed. But here is the key point. A will does not avoid probate. A will is a set of instructions for the probate court. It reads it and follows it. Assets passing under a will still go through Florida probate. Florida law has strict requirements for a valid will. Under Florida Statute 732.502, the will must be in writing. The person making it, called the testator, must sign at the end. Two competent witnesses must also sign in the presence of the testator and in the presence of each other. All three signatures must happen in the same session. Florida courts enforce this strictly. A will signed without two witnesses present together is not valid, no matter how clearly it states the person's wishes. Florida also does not recognize handwritten, unwitnessed wills, called holographic wills, even if another state would accept them. To make probate faster, most Florida wills are self-proved. Under Florida Statute 732.503, the testator and two witnesses sign a notarized affidavit, usually when the will is signed. A self-proved will can be admitted to probate without the witnesses appearing in court years later. Florida also allows electronic wills under Florida Statutes 732.521 through 732.525. They must be signed electronically during a live online notarization with a Florida notary and two witnesses connected by audio-video technology. This is not just signing a PDF. Strict procedures apply, and electronic wills cannot be used if the testator is a vulnerable adult. If a Florida resident dies with only a handwritten will, the court treats it as no will at all and distributes the estate under Florida's intestate succession rules in Florida Statute 732.101. A will is the foundation of most Florida estate plans, but it only works if it is executed exactly the way Florida law requires.